Get ready. Start. The provisions of Section 106 of the Evidence Act itself are unambiguous and categoric in laying down that when any fact is especially within the knowledge of a person, the burden of proving that fact is upon him. Stop thus, if a person is last seen with the deceased, he must offer an explanation as to how and when he parted company. Stop. He must furnish an explanation which appears to the court to be probable and satisfactory. Stop. If he does so, he must be held to have discouraged his burden. Stop. Section 106 does not shift the burden of proof in a criminal trial, which is always upon the prosecution. Stop. Para. When an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution. Stop. In view of Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give cogent explanation as to how the crime was committed. Stop. The inmates of the house cannot get away by simply keeping quiet and offering no explanation on the supposed premise that the burden to establish its case lies entirely upon the prosecution and there is no duty at all on the accused to offer an explanation. Stop. Para. The apex court in Trimukh Murthy Kirkan versus State of Maharashtra reported in within bracket 2007 10 SCC 445 reiterated as here under semicolon. Para. If an offense takes place inside the privacy of a house and in such circumstances where the assailants have all the opportunity to plan and commit the offense at the time and in circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstantial evidence, as noticed above, is insisted upon by the courts. Stop. A judge does not preside over a criminal trial merely to see that no innocent man is punished. Stop. A judge also presides to see that a guilty man does not escape. Stop. Both are public duties. Stop. Within brackets, see Still Land versus Director of Public Prosecution 194 AC 315 quoted with approval by Arijit J in State of Punjab versus Karnail Singh within bracket 2003 11 SCC 271. Stop. The law does not enjoin a duty on the prosecution to lead evidence of such character which is almost impossible to be led or at any rate extremely difficult to be led. Stop. The duty on the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. Stop. Here, it is necessary to keep in mind Section 106 of the Evidence Act, which says that when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Stop. Illustration within bracket B appended to this section throws some light on the content and scope of this provision, and it reads semicolon. Para. A is charged with travelling on a railway without ticket. Stop. The burden of proving that he had a ticket is on him. Stop. Where an offence like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, But the nature and amount of evidence to be led by it is to establish the charge cannot be of the same degree as is required in other cases of circumstantial evidence. Stop.